Before you proceed to deposition, before you proceed with trial, you must do a psychological report. And the psychological report is very, very important. We mentioned to you that it has to be objective, that you have to rule out alternative hypotheses, that you have to include information that may not be supportive of your position, of your opinion at the end, but you at least show that you've looked at it and document the reasons why you don't go with that hypothesis. So it has to be objective. How long should a psychological report be? Well, it depends upon how much documentation that you have, and it depends on how complex the case. It's not at all untypical to have a 15 to 40 page report in my practice, and that's single pages. And so you clearly want to make the report as long as you need to be to show that you have looked at all the factors that you need to be in an objective way and have demonstrated how you were able to logically get from the data that you've looked at to your opinion. And this is very crucial. You have to show the logical progression from the data to your opinion. And in just a little bit, I'm going to talk about some research done by Thomas Grisso on psychological reports that are not adequate. And that's one of the things that he stresses. Grisso looked at, for example, a whole series of reports submitted to the American Psychological Association for candidacy to become a diplomate of forensic psychology. And so these were people that supposedly were already forensic psychologists, and these are the weaknesses that were found in the reports that led to their reports not being accepted by the reviewers. One is, again, opinions without, that was the number one thing, opinions without sufficient explanations. You can't just say, this is my opinion. You have to explain logically how you got to that opinion. 56% of the rejected reports did not articulate the explanation of the data to their opinion. Then also, a lot of reports don't specifically specify or do not specify adequately the purpose of the forensic evaluation. And so you have to do that right off the bat. You have to say that this is a personal injury evaluation and describe briefly the trauma. It's not your job to prove the facts of the trauma. That's not your job. Your job is the psychological injury, the nature and the permanence, and how to make that psychological injury whole. And those are the issues that are important to you. So, but you still have to state in a very simple way what occurred, so that you provide some context to the gathering of your data. And then sometimes some of the reports were rejected because simply they had irrelevant data. And the opinions didn't have anything to do with the case. It didn't have anything to do with the purpose of the case. Now, how much raw data should you put in the report? I don't think you need to put all of the raw data that you excluded in your opinions. If it's contradictory, you need to mention that it was contradictory, but you don't need to put all the scores of the MMPI, of all the scales in the MMPI, for example, in your report. I don't believe so. I think you need to put enough in there to show that you've used the data in an appropriate and reliable way to come to your conclusions. And the other thing that was really stressed by Grisso when he looked at all these reports that were rejected as being inadequate was over-reliance on one source. I think it's a part of our emerging standards of care, or our current standards of care, that you triangulate data, that you use data from multiple sources, and so you must do that. Otherwise you cannot address, for example, again, things like malingering and exaggeration of symptoms. And then finally, 15% of all the reports were rejected because of improper test use. Now, what is that? That means, for example, they used a test that was not normed appropriately. For example, we've already talked about the Milan. There's a whole lot of questions about it over-exaggerating symptoms. So if you base your conclusion on the Milan, that would be, I think, an inappropriate use of a test that has not been found to be reliable in the literature as a tool that can help you come to good conclusions about the personal injury cases. So again, anywhere from 10 to 40 pages to 50 pages. It's difficult to say how long they should be, but they should be adequate enough to describe your opinion, the sources that you have, and to clearly articulate that you've ruled out alternative hypotheses and why you came to the conclusion that you did. So a brief outline should be, for example, identifying information, sources of information, a review of the assessment data and interpretation of the data, a special section, I think, on assessment of malingering because it's so crucial. So why not have a separate section on that where you use the tools that we talked about, then your opinion, and then summary and conclusions, so that the trier of fact, the judge or the administrative law judge or the attorneys presenting to the jury can appropriately summarize your findings and your conclusions. So a report, again, should be adequate for this purpose. And I am opposed completely to submitting preliminary reports because often attorneys will use those and those preliminary reports in a way that you do not intend. So I would not give a preliminary report. It's all right maybe to talk to the attorney about where you're going and maybe even some of the facts and the testing results that do not support maybe what he would like or what she would like, but I'm opposed to writing any kind of preliminary reports before the final report, and because you never know, how the attorneys will use that, and it can and does frequently end up in a situation that you do not, that you do not approve of.